For the record, this matter is before the court on the plaintiff's first motion for temporary relief. This newly filed divorce action. This hearing is being conducted via Zoom. President Attorney Leslie Carr representing the plaintiff Stephen Howard. Mr. Howard appears to be present. In addition, Attorney Kimberly Kuhn is present representing the defendant Rebecca Howard. Ms. Howard appears to be present with Ms. Kuhn. Good morning, everyone.
Good morning, Judge.
Good morning.
The parties have conferred at length with Mr. Walker this morning from the front of the court. Mr. Walker has provided the court with fine recommendation that on a temporary basis, without prejudice, the parties shall share joint legal as well as joint physical custody of the minor children. Parties shall have a reasonable liberal parenting time schedule with the intent of a 50-50 equal parenting time schedule. One of father's weekend parenting times will occur when mother has to work. Mother will provide her work schedule to father. The parties shall split and divide the vacation fund bank account ending in account number 5752 on June 1st, 2024. And that account shall be closed. Mother shall receive an additional $400 from that vacation fund. And presumably, mother will receive the first $400 and the balance will be split equally. Is that correct?
Yes,
Your Honor.
Right. Finally, a mutual restraining order concerning property will issue. And no third party having a romantic interest shall be in the presence of minor children while this divorce action is pending. Neither party shall disparage the other party or allow any third party to disparage the other party in the presence of the minor children. Party shall maintain the status quo in terms of marital bills. Each party may spend $4 per month for personal use starting June 1st, 2024. That is a recommendation. Ms. Carr, is this recommendation agreeable with your client this morning?
Yes, it is.
Thank you. Ms. Kuhn, is this recommendation agreeable with your client this morning?
Yes, Your Honor.
Thank you. The court noted in the file that there was mediation on May 3rd. Did that actually occur?
It
It
did.
did, Your Honor. And we have a subsequent mediation scheduled on June 28th. We had some issues that we were able to resolve, but not all issues. There was some discovery that needed to be done. And so we're hoping that on June 28th, we can resolve the remainder of the case.
With whom is that scheduled? What time on June 28th?
It's scheduled with Ms. LaPrade, and I believe,
It's at 8:30, Judge.
yes.
8:30? Right.
Do you want us to report in after mediation?
Yes, because the court wanted to schedule a pretrial, but the court will do send out notice that the party shall mediate with Ms. LaPrade. Any objection to the court ordering that mediation with a subsequent pretrial?
No, Your Honor.
Judge.
That's good. Never going to right. So June 28th, 8:30 a.m. mediation with Ms. LaPrade, followed by a pretrial conference before this court. Ms. Carr, Ms. Kuhn, do you wish to voir dire your respective clients regarding this recommendation this morning?
We're fine, Judge. We don't need to, but thank
No,
you.
Your Honor.
Right. Right. The court will adopt the recommendation. I'd like to thank Mr. Walker for his assistance, as well as, of course, attorneys Carr and Kuhn for helping facilitate amicable resolution, helping these parties work through these differences. The court greatly appreciates that. What about the Social Security cards? Is
That was all
not
taken
addressed?
care of. So that
Right.
is not an issue anymore.
Right, good. Right, thank you, Ms. Carr. Thank you, Ms. Kuhn. That will conclude this hearing this morning. Everyone can zoom out. Have a good rest of the day.
Thank you, too, Your Honor.
Placed on this court's docket at the request of the friend of the court. The friend of the court referee made a determination that the plaintiff mother be held in contempt of court. And the hearing on the contempt issue will be addressed by this court today. This hearing this morning is being conducted via Zoom. Is Amy Henning Rowe present? Oh, there's Miss. You are Amy Henning Rowe. Is that correct, ma'am?
Amy Hennings Rowe, correct.
Right, good morning. In addition, Attorney Leslie Carr is present, representing the defendant, Father Jonathan Hennings. Mr. Hennings is present. Good morning, Ms. Patrick.
Good morning, Your Honor.
The court's review of the file indicates that the defendant mother did not file an objection to the referee recommend order of contempt of January 19th. That also provided that she paid $1,750 to the plaintiff. The cost of on or before March 31st of 2024. and that she provided the children's medical records by February 13, 2024. The court's understanding is that there was a mother never filed a timely objection to that recommendation. Is that correct, or did the court miss something in the court file?
That's correct, Your Honor. There was no objection filed to that order.
Ms. Henning, I'm sorry, Ms. Carr, has your client received the child's medical records? Which will
No,
be provided by February 13th.
no, he has not.
Has your client received the $1,750 that was to be paid by Ms. Rowe on before March 31st?
No, he has not.
All right, so just here to enforce an order of the court. Is that correct?
Yes, Your Honor.
All right, Ms. Rowe, it's certainly order of the court. Unless you go to the Court of Appeals to appeal it, it's the only thing for this court to do is enforce that. Can you pay that sum by the end of this week? It's overdue.
Yes, I can. I didn't know I'm supposed to pay it to Jonathan Hennings. I thought I had to pay the court.
I also thought the same thing.
Okay.
I've never had to do this. I apologize.
Okay, so it's just a question of who it's paid to. Ms. Patrick, again, this was the referee that imposed these fines. Is that paid? Do you have, is there a general fund in your office?
Your Honor, it would be added to the existing account. We would just pass it through to Dad. So it can be paid at the front of the court. And what we'll do is we'll add it to the child support account, and we'll make a line that's payable to Dad. That Ms. Rowe would be the payor, and we would make Mr. Hennings the payee.
Mr. Hennings is currently paying child support, so it would be a credit against child support? Is that what it would be?
No, Your Honor, I would not credit against the child support. I would just add a separate line as like a fee line, and then I would put it through that way.
Okay. Are there any child support arrearages outstanding?
Yes.
I
Yes.
can- Hold on, Your Honor. I'll look really quick for the court. There, Your Honor, there is as of the end of April, there's an arrears of $2,061.88.
Mr. Hennings, do you acknowledge that there's outstanding arrearages, about $2,000?
I do acknowledge it.
Okay. I mean, rather than Ms. Rowe having to pay that, could the court not simply order that Mr. Hennings receive a credit of $1,750 against the outstanding child support arrearages?
Your Honor,
Yes, Your Honor.
Your Honor, if unless you feel free to cut me off, but it's not, I don't, that's a lot of money. And I'm not happy, but that's a lot of money. I don't want to fault the mother, but I just want the medical records. And I $1,000 is a lot of money to a lot of people. So as upset as I am of not receiving the medical records, I if I could ask, I do not want that. You know what I mean? I thought the fine was going to the court. I am, you know what I mean? So those arrearages I owe, I will pay those in timely. But I don't think it's right. I don't know if I'm communicating this effectively because I'm shocked. This isn't about money. I don't want the money. I just want the medical records so I can know what's going on with my daughter. And if I've stepped out of bounds, Leslie, feel free to reel me back.
Fine.
Right. So Mr. Hennings, you're asking the court to waive the collection of these fines that were previously imposed?
If I can have the medical records within a fair amount of time, yeah, absolutely, sir.
You understand that the reason the referee imposed fines is to get someone to take action. So for this court, if we're not going to assess costs, the only alternative for this court is to put Ms. Rowe in jail. You understand that?
I wouldn't want that either. And again,
okay, well, Mr. Hennings, how does this court enforce orders without imposing costs, fines, financial penalties, or putting someone in jail? So if in fact you wish to waive your right to that $1,750, we can do that, and that'll eliminate that. But this court is bound to come to enforce orders. That's part of this court's job, is to enforce court orders. So if Ms. Rowe is not going to provide those medical records, then it gives this court no alternative but to impose a jail sentence.
Understood.
So Ms. Rowe, Again, obviously, Mr. Hennings is being most reasonable. He doesn't want the credit against arrearages. He's not concerned about you having to pay the $1,750, so that can be eliminated. But the child's medical records, those need to be provided.
May I speak to you, Your Honor?
Well, when will they be? They were supposed to be provided by March 31st. It's now almost May 31st.
I
When will you
understand.
provide those?
I understand, Your Honor. I believed that that order was provided by the referee in direct conflict with your original order stating the girls had protection under HIPAA, that they had protection for their primary mental health and ladies' health to be protected. So I was trying to retain an attorney to address this matter. That's the only delay. I did speak to the doctor about getting those records, and she told me that they'd already been subpoenaed and provided. So I was very confused about it. If I have to go get those records, I can do that today. But I believed that it was in a direct violation of your original order that the girl.
What order? Hold on. What order are you referring to, Ms. Rowe? Give me the date of the order. I don't know what order you're talking about.
I'm so sorry, sir. It was the first petition from Mr. Hennings that he have the girls' records in 23. And you ruled with Mr. Stimpson that it was, there's a violation of their HIPAA law protections. They are of age and they can go request their records. They are of age.
Not a 15-year-old. Again, I don't know what order you're talking about, so you need to come back and then provide with court the content order. Give me the date of that order. I got a court file right here. I'm not aware of any order. Ms. Carr, are you aware of any order?
I'm not aware of any order that states that the medical records cannot be provided. No.
Right. So, and the other thing is you, Mrs. Rowe, you have an obligation to keep father informed of any medical appointments.
Yes, sir. And I do.
In advance, not 3 hours in advance. And you schedule those appointments and you probably schedule them weeks in advance, correct?
No, sir. A lot of these appointments are emergency urgent care appointments. My daughter's been in the emergency room 3 times. She's been to urgent care twice.
What you do is you text or app close with Mr. Hennings immediately upon making the decision to go to the emergency room. That's where we're heading the emergency room. This is where we're going. Toledo, Ann Arbor, Monroe. And so that he has the right to be present. Yes,
I have done that, sir. Every time. The complaint is that I didn't notify. The complaint is I didn't do it in enough time. Sometimes I'm at work and someone else takes her.
That's not true.
The father won't take her to doctor's appointments.
Again, not true.
Mr. Hennings, I can provide the court records from her text where she's asked.
Right. The two of you are not going to argue this. The issue, the court will take testimony if necessary.
Yes, sir.
Mr. Rowe, the court will not tolerate you not cooperating with the father of the children.
I indeed am not, sir. I agree.
And if court calls you contempt, the only alternative is jail. You understand that? I
do understand that. And if you want me to provide the medical records, I will go get them today if the doctor will cooperate.
Okay. How will you deliver those? You can deliver to Ms. Card, Mr. Hennings.
I don't know.
I would defer to Ms. Carr.
My office is open, so if she would like to drop those off at my office, we will accept those.
I have to pick up my children at school at 3:45, so this can, I have to make sure the doctor will provide them. They have a lunch hour, they close. And I know these records are very full. She told me over 350 pages. So I don't know how long she'll take to prepare them. If an electronic record is not available, the doctor only works in paper documents, which is sad.
Ms. Carr, what do you suggest? Obviously, if there's 300 pages, someone's going to have to pay for those.
And it's pretty.
And I understand that. And we in the past had subpoenaed records from that doctor before. These records that we're requesting are since that original subpoena, and we had to pay probably about $180 to $200 for those records at the time.
What is the date, ma'am? So I can tell the doctor.
Hold on, Ms. Rowe.
The years
specify what exactly you're seeking. Medical records from and after what date?
Medical records for the minor child Peyton for the years of 2022, 2023, and so far this year.
So 2022, 2023, and 2024.
Yes,
And your client will reimburse Mr. O for the cost of those records if it's not available on electronic?
yes, he will.
Okay. So Ms. Rowe,
Yes, sir.
um,
Your Honor,
yeah, you're going to consult an attorney, is that correct?
yes, sir. I consulted an attorney on Friday when I was notified of the hearing by Catherine Scott. I'm not getting mailings in a timely fashion in order to object or appear. I'm a nurse in an ICU step down and my schedule's made 2 months ahead of time. So I don't have the option to not go to work. I have to go to work and then try to Zoom from work, which doesn't work when someone needs a blood transfusion or has a stroke. So
Right.
I've been trying my best when I know of the hearings, but I need more notice, unfortunately, with my
Okay.
job.
All right, so we're talking about just a 15-year-old daughter, medical records, correct, Ms. Carr?
Yes, that's all.
All right, so Ms. Rowe, you ordered to secure and provide to Ms. Carr your 15-year-old daughter's medical records for the year 2022, 23, and 24 on or before May 31st.
Okay.
And you ordered to appear back in this court for a review on June 5th at 1:30.
Oh, June 5th. Okay.
Let me look at that.
Give you some time, and
Yes, sir.
I'm telling you, there's a really good chance you're going to go to jail if you don't have those records by the 31st.
Okay.
if
June
you have
5th
to
at what
pay-
time, sir?
1:30.
1:30. Yes,
So
sir.
this matter is adjourned to June 5th at 1:30. Ms. Patrick, you can revise your recommendation. I've not had a chance to look at it, but I will note that Mr. Jennings is waiving any he's waiving the right to the contempt fines of $1,750. If those medical records are provided, Ms. Carr, will that address the situation? Would you still need to address communication for future medical appointments?
As long as those medical records are provided, I think we've addressed the primary issue, as long as we keep getting notice of the appointments. There's just been a recent complaint filed recently that the child had a med review, and it was put on the calendar the day before, and med reviews are scheduled well in advance. So
Yes. I'm sorry, the situation merited. Peyton was not a part of that appointment originally. I got her added at the last minute because she wanted a review of her medications. She was not originally a part of that appointment.
Do you guys see these loopholes and these things that magically happen every single time there's an appointment?
Well,
That's a general statement.
I guess, Ms. Rowe, unless you're taking the emergency room, then any reason why the court should not, Ms. Patrick, any thoughts you have that maybe she should provide at least 48 hours advance notice of any medical appointments?
At
Unless
least,
it's an
Your Honor.
emergency room visit.
Sir, what about urgent care and sick days?
No, unless it's emergency room.
Your Honor, I would
Or
agree.
an emergency
that
room.
issue
I'm
going
sorry,
on in
hold
this
on,
case.
Ms. Rowe, Ms.
I
Patrick, any
apologize.
suggestions, recommendations in terms of the notice? That'd be reasonable.
I suggest that she gives 2 weeks notice of any medical appointments except for emergency rooms, which she should be able to give at least 30 minutes notice, because if you're going to the emergency room, you know, she should have at least 30 minutes notice on an ER visit, but 2 weeks on anything else. This, as the court knows, because you've reviewed the records, this has been an ongoing issue with these parties. They've been in the front of the court for 13 years, and we are having issues of the orders not being followed. As Ms. Carr stated, another complaint has been filed.
Right. Ms. Carr, do you think 7 days notice would be sufficient rather than 14? Did that give Mr. Jennings enough?
I think 7 days would be sufficient, yes.
All right, so Ms. Patrick, the court will order that to Ms. Rowe provide 7 days advance notice of any doctor's appointments, and at least 30-minute advance notice of any emergency room visit. Now, what about quick care? If on a Saturday she's going to a quick care clinic, I mean, obviously you're going to wait a couple hours in that. I mean, she should be able to give 30-minute advance notice to any emergency room or quick care clinic.
I agree, Your Honor.
All right. So that the court's gonna order that to Ms. Rowe. And this court's gonna enforce it. I'm telling you, Ms. Rowe, because if you want to push the court, you can spend a weekend in jail.
Sir,
So that's what the court's gonna order. The court's gonna adjourn this matter to June 5 at 1:30 in order to provide those medical records for 15-year-old daughter to Ms. Carr on or before May 31st, 2024. And you can come back with an attorney if you disagree with the court's ruling this morning.
yes, sir. Thank you.
All right, if you could revise your recommendation, Ms. Patrick, and Ms. Carr, anything further?
No, thank you, Your Honor.
I,
All right,
I
Ms.
have a
Rowe?
question. Yes, sir.
Go
I have
ahead,
a
Ms. Rowe.
question.
Go ahead.
Parties stipulate that we get email notices of court business because I'm not getting mailings in a timely way. Can that be stipulated?
That's already done,
No,
Your Honor,
you
by
can't
the
do
front of the
email
court.
communication. Ms. Patrick?
That's already done by the front of the court, Your Honor. My policy at the front of the court for all mailings is we email them if there's an email address on record at the front of the court, and we mail them. So her notices have been emailed and mailed.
And I can notify the court, the friend of the court directly for a new email address?
Yes.
Okay, great. Thank you.
Does she need to come in and sign and fill out a form, Ms. Patrick, or can you do that just over the phone?
She can do it over the phone, Your Honor, or she can send us an email. She can also update her My Child Support account, which will automatically update the system.
Oh, that's good.
And if you pay for those medical reports, Ms. Rowe, provide a receipt to Ms. Carr so that Mr. Hennings can reimburse you.
Thank you, sir. Can Mr. Hennings be also helpful, responsible to take Peyton to these appointments?
I don't know why not, Ms. Carr.
And I could schedule them on my schedule, and I would be open to that. The issue with that, Your Honor, is that there's still a court order that have to pick the children up from the police department. So, you know, and my daughters both have shared there's still questionable characters at that house home. So I would definitely want to keep that court order at the police station. So if Mrs. Hennings Rowe wants to meet me at the police station, I can pick up Peyton and take her to these doctor's appointment. I'd be more than happy to. And again, you know, around my schedule for once.
The issue, sir, is that Peyton calls her dad from school or some other place when she's sick and I'm at work. It's only when I'm not available that she calls her dad.
So med reviews. I mean, we're not talking
Sick visits.
All right, Mr. Hennings, you talk with Ms. Carr about that further. We can address it if necessary further on June 5 at 1:30.
Understood.
Does this negate the May 29th appointment, Ms. Patrick?
Yes, the court overruled it and moved it to June.
Thank you, ma'am.
All right, if there's nothing further, that will conclude this matter. We can zoom out. A copy of this order will be mailed to both parties.
Thank you, sir.
Thank you.
Thank you, Your Honor.
Hennings Rowe versus Jonathan Hennings.
For the record, this matter is before the court for review of outstanding issues, including but not limited to possible contempt proceedings relative to the plaintiff mother. This hearing is being conducted via Zoom. Present is plaintiff Amy Hennings Rowe. In addition, Attorney Leslie Carr is present representing the defendant, Father Jonathan Hennings, and Mr. Hennings is also present. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Parties were last before the court May 21st. The court ordered that the plaintiff mother provide the children's minor child's medical records within 2 weeks to Attorney Carr for the years 2022, 2023, and 2024. Has that been accomplished, Ms. Carr?
Yes, it has. It was accomplished within the week. Ms. Hennings Rowe did front the cost for those, and I have forwarded a check to her in the mail, reimbursing her for the cost of those.
And if the court recalls, Mr. Hennings was kind enough to waive the fees that were previously ordered that Ms. Rowe pay Mr. Hennings, totaling $1,750. Is that correct?
That is correct, Your Honor.
Right. Any other outstanding issues then that need to be addressed today, Ms. Carr?
No, at this point in time, we're satisfied that the court's order has been abided by, and we would withdraw our show cause.
All right. Ms. Patrick has provided such recommendation. The defendant withdraws his show cause petitions at this time as medical records have been provided. Ms. Carter, the parties do share joint legal custody, is that correct?
Yes, they do.
All right, so, Ms. Rowe, hopefully you don't need to come back on the same issue. I mean, there's still an outstanding contempt out there. Whenever your daughter needs medical attention, you need to keep Mr. Hennings informed of that.
Yes, sir.
Emergency room visit, pediatric appointments, dental appointments, just for his information. Let him know when it is and with whom.
Correct. Yes, sir.
He has a right to have that information.
Yes.
All right, anything further, Ms. Carr?
No, thank you, Your Honor.
All right, that will conclude this matter. Ms.
Thank you.
Hennings, well, it works both ways. Mr. Hennings clearly has worked with you, and you got to work with him and cooperate with him. Before you know it, your daughter's what, 15?
Yes.
Going on 16. She's going to be an adult real soon. So work together for her best interests. All right, that will conclude this hearing. Everyone can zoom out. Have a good rest of the day. Thank you, Ms. Patrick.
Thank you, Your Honor. Have a nice day.
Thank you, Your Honor.
You're welcome. For the record, this matter is before the court for the purpose of reviewing parenting time. This hearing is being conducted via Zoom. Present is Attorney John Filkins, representing the plaintiff's mother, Ms. Mayoris. In addition, Attorney Karen McDonald is present, representing defendant father Robert Pollock. Both parties are present. Good afternoon, everyone.
Good afternoon, Judge.
Good afternoon, Your Honor.
One moment, let me access the recommendation of the friend of the court this afternoon. The court has received the following recommendation that the parenting time review be adjourned to July 16th, 2024 at 2:30 p.m.
Your Honor, if I may.
Yes, Mr. Filkins.
Yes, Your Honor. The issue comes down essentially to this. The reason for recommending the July 16, 2024 at 2:30 p.m. was because of the fact that the counseling that we had agreed to back in April, that we let the court know about when we were last here, April 16th of 24, has not yet commenced. Attorney McDonald has indicated to me that there was an issue with insurance. And so it was proposed to move it out to allow for the counseling to occur. But here's my inquiry of the court, and that's the reason for needing to speak with you is it possible, rather than scheduling it for July 16th at 24, that we just not reschedule it until such time as the counseling has taken place, and then there could be a request for a hearing? So I just wanted to get your input. I know that Attorney McDonald is more desirous of having it July 16th at 24, but I guess we just need the court's input on this issue.
I actually, Your Honor, I disagree with Mr. Filkins. I would like a date set. We're currently having parenting time under a temporary order from February 2nd, 2014, which was obtained ex parte. Objections were filed to it. My client had an issue with insurance, and we're here approximately 30 days after our last court date. I would like the matter set for hearing.
Understood, and obviously the court prefer just leave it open-ended, but obviously if someone requests a review date, Mr. Filkins, the court's inclined to accommodate that. It's much easier than trying to reach out, get a date. If we can set it today, we have everyone's schedule here. Has there been a deposition taken of the child's counselor? I know that was discussed when the last present.
Yes, it was.
Okay. And there was also some discussion about a psychological evaluation of the defendant. Is that still being contemplated?
Actually, I requested psychological evaluations of all the parties and the minor child. Mr. Filkins has not agreed to it.
Okay. All right. Was a deposition of Mr. Jardin, was that helpful?
Mr.
Insightful?
Julian?
Mr. Julian.
It was helpful to me, I think. I don't know that the minor child is still treating with her. I think she stopped treating with her. In fact, I know according to her deposition, Your Honor, which was taken, I'm sorry, I'm just looking at the date, on April 11th of this year, so just 5 weeks ago, she wrote this court a letter on the 18th of January. And from the time she wrote the letter on the 18th of January, from the time of the original ex parte order, which was entered, suspending my client's parenting time, to the date I took her deposition, she had less than 4 sessions with the minor child. So she, as of once ex parte relief was obtained, I would argue she stopped treating the minor child. I haven't seen updated medical records, although I intend to send a subpoena for the same.
Yeah,
Okay.
you might as well issue the subpoena for same, because I've been advised by my client that she has continued counseling with Mr. Julian. And in fact, she has an appointment scheduled today that's been booked for a period of 4 weeks.
All right, well, then I stand
Okay.
corrected.
The only letter the court received from Mr. Julian was dated January 18th, 2024, but there was a subsequent letter, if so, that was sent to the front of the court, not this court.
Yeah, that was the letter I was referencing, Your Honor, was the
Okay,
January
all right.
18th, 2024. Thank you.
Okay. Well, at least you did answer the court's question and that the deposition did take place. All right, the court will in fact file the recommendation to adjourn this matter, put it back on our docket July 16th at 2:30 p.m.
All right.
Thank you.
Thank you, Your Honor.
You're welcome. That concludes the matter. The copies we mailed out to council. Have a good rest of the afternoon.
You do the same.
You too. Thank you very much.
For the record, this matter is before the court for the purpose of reviewing parenting time. Also before the court is the defendant's request for an evidentiary hearing. This hearing is being conducted via Zoom. Present is Attorney John Filkins representing the plaintiff mother, Ms. Mayoris. And Ms. Mayoris appears to be present. In addition, Attorney Karen McDonald is present representing defendant father Robert Pollock, and Mr. Pollock is present. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
And the parties have conferred with Mr. Pratt. This afternoon is provided the court the following recommendation that the current court order continue and remain full force in effect. As pending time for Sundays, 10 a.m. to 6 p.m. with no additional third parties. There should be no discussion of the case with the minor child. It's noted that Mr. Pollock is allegedly violating the court's order in regards to having a third party present in the presence of a minor child. That is the defendant's significant other. Further, it's recommended that father of my child attend counseling with Candace Worthy. And father will initiate that appointment. That is the recommendation this afternoon. Mr. Filkins, is this recommendation be with your clients this afternoon?
Your Honor, if I could just indicate one other matter that we're here for today at this time is the petition to show cause that I filed against father for father's violation of the prior court orders. But with that being said, my client would be in agreement with the recommendations.
Right, I did see that in the pleadings, Mr. Filkins. I wasn't aware that was noticed up for hearing today. You're asking the court to what? To hold Mr. Pollock in contempt?
That is correct, Your Honor.
All right, then court's recollection of the pleadings that Ms. McDonald on behalf of Pollock acknowledges having that third party present, but that once it was brought to her attention, she instructed Ms. Pollock to immediately discontinue that, which he did. All right, and Ms. McDonald, the court is it's a point well taken that you're asking for an evidentiary hearing in this matter. Is that correct?
It is, Your Honor. I think it's gone on for quite some time, and I realize that it takes a lot of temerity when admitting to violating a court's order to come in and then make additional requests. But I feel that it's not only in the best interest of the minor child, but also best in my advocacy for my client to request that.
It's a point well taken. And reviewing the pleadings at one time, counsel was suggestion that the parties and the child be evaluated by Dr. Douglas Parks in terms of I guess a custody parenting type of evaluation. Has that been discussed any further? Is that still on the table?
We did discuss it, but I think that the parties are in a financial position, and I don't think Mr. Filkins wanted to pursue that. I think there's a financial barrier there that would not be overcome.
Would you agree, Mr. Filkins?
Agreed.
All right. The court, it's a point well taken from Attorney McDonald. Of course, the ex parte order entered in October 23 was entered by a different judge in this court's absence, Judge Lohmeyer. And prior to that ex parte order being entered, father had parenting time the first weekend of every month, Saturday at 10 a.m. to Sunday at 10 a.m. It was not significant, but he had some overnights. First weekend, Saturday, 10 a.m. to Sunday, 10 p.m. The third weekend of the month, Saturday, from 10 a.m. to 7 p.m. and Sundays, 10 to 7, and Thursdays, every Thursday, 3:30 to 6:30. And Mr. Filkins, your client's opposed to this court reinstating the parenting time that was practiced from 2000 for perhaps 9 years, from 2014 to 2023.
Yes, based on statements obtained from the child's counselor that I'm prepared to present her testimony based upon the court's own counselor interviewing the child. That counselor recommended that the schedule be what the schedule is presently, Sundays, for those several hours without the significant other of the defendant being present. Third, based upon the fact that father can't abide by the court's order. He takes it upon himself to violate the order. And I'm suggesting too that this happened on at least 5 different occasions he violated the court order. And it wasn't until after that 5th occasion that we found out that he'd been violating the order. I would also indicate to the court that it's been father's request to get a counselor involved. And each time this case gets continued, he's indicated, I've reached out to this counselor to get it scheduled. I need additional time to check on insurance. And then we find out today, for the very first time, that he's saying he can't go to this counselor because the counselor is not available at any other time than during 9 to 5, Monday through Friday. Today was the first time he brought that to our attention. How long has he known that? I have no idea. But he's not followed through. If he really wanted to have counseling between himself and the child, wouldn't he have found out what the availability of the counselor was back when we were in court back in May?
Well, we certainly could have moved forward much quicker. The court would agree, Mr. Filkins. But right now, is dad's home suitable for this child overnight?
Of course.
Does the
Of
child
course
have
it
her own
is.
bedroom?
Yes, of course she does.
Yeah, likewise, the one the court had is why hasn't father-daughter joint therapy or counseling begun? And this order was entered almost a year ago.
I agree. I agree.
And Your Honor,
and
that's my client's failing, Your Honor. And it took almost 6 weeks to just agree on a counselor. Today, we finally capitulated and agreed to plaintiff's counselor because we have to get it moving. And the whole point of stipulating to the counseling, Your Honor, was in an effort to help rebuild this relationship, to rebuild. There was a terrible incident, family argument in October. An ex parte order was entered. Then an order was entered for my client to reinstate his parenting time. And his live together partner appeared on one occasion. And then the parenting time reverted back pursuant to the recommendation from friend of the court. The minor child was interviewed 6 months ago. Plaintiff delivered her to the interview. My client since then has had his 14-year-old daughter who has lived in the household with him and his live together partner, Yana, for almost 12 years and asked him repeatedly to let her see her. He knows he did the wrong thing, which is why he immediately admitted to it. And I corrected the issue with my court or with my client before anything was ever filed with the court. But the contempt was filed nonetheless. In addition to that, Your Honor.
What was he thinking, Ms. McDonald? He could do what he wanted to?
No, I think he was thinking that he wanted to make his daughter happy. He wanted his family together again. And Your Honor, I think that was foremost in his thoughts. I do not believe that Mr. Paluk was cavalier about the court's order. His daughter has expressed to him many times. And once I realized the issue, Mr. Filkins alerted me to it. I reached out to my client and I said, look, it doesn't matter how much she asks or anything like that. It's a court order is a court order. And until it's modified, it remains in full force and effect. And there's consequences for violating it. So don't do it anymore. So I immediately helped him clear the contempt. And here we are today.
Your Honor, if I could just very briefly direct your attention to my interrogatories posed to Mr. Palou. I asked him on each of the specific dates in which he exposed the child to his significant other during any of your parenting time with a minor child, was Yana Galanin present? His response, I do not know. I do not keep a calendar. She may have been in the house, but did not interact with me or Adriana. if he's freely admitting the violation, then why is he hedging? Why is he running around the issue? The bottom line is he went against the court order, and now he's trying to give some excuse to the court that, well, I got the input from the child. He never reached out to my client about it, never reached out to the child's counselor about it, never obviously involved his attorney to write us a letter to say, hey, Adriana is saying she wants to see this person. Is it okay? So it's just frustrating at best.
Your Honor, I think I would have to take issue with those remarks. Michelle DeJulian, who was deposed, has never spoken to my client. She's met my client on 2 occasions. She's never invited him to the office. And the remarks that she's written to this court about my client make him sound like nothing short of a monster. I took her deposition, and I look forward to putting her on as a witness at evidentiary hearing, because frankly, there are some serious concerns regarding her approach to this minor child, not to mention my client. In addition to that, Your Honor, I have repeatedly asked every time we've been here to lift this restriction regarding my client's live together partner. I didn't have the moxie to ask for it today because we're not in a position to do that. We violated the court's order. With that being said, Your Honor, I've tried to work this out. I have, which is why I just had to ask for an evidentiary hearing. Plaintiff is asked to suspend my client's parenting time. He's been granted this restricted parenting time with no overnights. And if plaintiff wants to continue this parenting time schedule, we have to analyze the parenting time factors, and evidence has to be presented to this court as to why my client is so dangerous that he cannot have overnight parenting time, and his live together partner is so menacing that she cannot be present, and why that should be a permanent order of this court. And that hasn't happened so far.
Court understands your position, Ms. McDonald. Of course, your client now brings his credibility into this whole matter. When he even answered an interrogatory, well, I'm not sure. I don't keep a calendar whether she was around. Obviously, there's a pretty clear order of this court. So I'm just saying, if we need to go there, we can go there. But he's brought his own credibility into this issue. The court agrees the child's not been in danger. She's 14. If she feels she's threatened or in danger, she can call her mom. So we'll set an evidentiary hearing. This court's going to adopt this recommendation until we have that hearing. So if everyone has their calendars, the court agrees he's entitled to a hearing. And sometimes those hearings create more animosity between the parents. I can tell you that time and time again. They'll start throwing little pebbles at each other, start throwing stones. It's going to irreparably damage the relationship between these 2 parents. That's this court's experience in family law. I did a number of 20 years as a private practitioner, now 10 years on the bench. It will create problems. And the last thing the young girl wants to be is in the middle. And I presume you want her to be interviewed by the court. I mean, no child wants to be interviewed by a judge. But if these parents can't figure it out between them, and the court agreed, we should talk about some expanded parenting time. Will this Mr. Julian, will she meet with dad? Has that ever been?
No.
She won't meet with him?
She will not.
All right.
Wait a minute.
Of course, if you subpoena her, I will tell you, in my experience, if you subpoena her to court, she'll probably drop Adriana as a client. I mean, a lot of times they don't want to come to court, and counsel, you should both know that. They'll help with the families, but she may well drop Adriana if she's going to be subpoenaed and have to come to court and testify. But we'll leave that to the parties.
But I would just let the court know that I have never received any indication from Michelle DeJulian of either of the following. She's never indicated that she's not willing to speak with father. Rather, she says she's never received any communication from father wanting to meet with her. Okay. If the idea is she needs to reach out to him, I guess I could encourage her to do that. So that's issue number 1. Issue number 2 is she's prepared to testify. She's indicated previously that she's willing to testify. So I don't anticipate that she's going to drop the child as a client and refuse or say that she doesn't want to testify.
Well, that's good. But Ms. McDonald, court certainly say encourage Mr. And I'm sorry, am I pronouncing it incorrectly? It's not Pollock, it's Palu. Is that the correct pronunciation?
Palu, yes.
Palu, I'm sorry. I would strongly encourage Mr. Palu to reach out to her and then maybe meet with her in terms of what can I do to restore my relationship with my daughter. I mean, that's a pretty given, but in any event, with that having been set, if we have your calendars out, can you do this in half a day evidentiary hearing?
Yes, I just need one moment. I'm sorry, Your Honor.
Okay, do you want a hearing in August or going to September?
August would be preferable, Your Honor.
Okay, mid-August, late August?
Perhaps the week of the 19th.
Okay, I've got my docket days are Tuesdays and Wednesdays, pre-trials on Fridays, so I conduct hearings on Mondays and Thursdays. So we have Monday, August 19th at 1:30 or Thursday, the 22nd at 1:30.
Thursday, the 22nd at 1:30 would be preferred by me. I'll do what meets with Mr. Filkins.
My only question, Your Honor, is that going to be sufficient time if we're going to have Mr. Julian, maybe the counselor who's coming in from meeting with child and father, if that occurs between now and August 22nd, and the parties, and I'm assuming that father's significant other may testify. My only concern is that enough time?
Okay, so you want a full day, start at 8:30 then?
I'm just suggesting that so we wouldn't have to come back on a second day.
Okay.
John, I'm out of the country on the 22nd. I'm out of the
Okay.
country. So,
All right.
How about the 29th, 8:30 in the morning for a full day?
Right now,
29th of August?
yeah, I cannot do August 29th because two previously scheduled hearings. I have one starting at 10 and the other one starting at 11.
What about the 26th of August?
Yeah, right now I have a hearing that's scheduled to start at 9:30 and run till 12:30.
Okay, we're going into September then, September 5, Thursday.
I can do September 5.
Ms. McDonald?
I have something that day, Your Honor, but I'm going to move it.
Okay, right, court mail out notice will be an in-person hearing, September 5, 8:30 a.m. in person. The court would request trial briefs from each party on or before Friday, August 30th, or Friday before that. Do we need to establish the time frame which you'll exchange witness lists? How much time do you need for that?
About witness list by August 14th.
Fine with me. Your Honor, are we going to address the contempt issue on
Yes.
that day as well?
We'll do it today.
Okay.
I'm sorry, so exchange witness list August, you say 15th or 16th, Ms. McDonald?
I said 14th, August
Oh,
14th, exchange witness lists.
Okay,
That's Wednesday.
I have no objection to that.
okay. I'll notice this in the no superior witness list, exchange August 14th, trial briefs. Do August 30th. Okay, and set a date which the court will interview the minor child. In the interim, of course, the court would urge the parties, the parents, to work out their own resolution of this matter, rather than put their daughter through all this. So if the court interviews a minor child, then Wednesday, September 4th. Mom, can you get your daughter here in the afternoon, maybe 4 o'clock on September 4th?
I will if I can. She will have cheerleading practice because school will have started, but I can see if she can miss it. Your Honor.
Okay. Does she have cheerleading every day that week?
Yeah, she'll have it every day with games on Friday. It's Labor Day week though, so, but I would imagine she would.
Okay. Well, she's gonna have to tell her parents want her to go to court, so we'll set it to bring her here, producer at the court's office on Wednesday, September 4th at 4 p.m.
Your Honor, may I ask a question?
Certainly.
The minor child was already interviewed by the court for the recommendation. Is it necessary for her to be interviewed for a second time?
It is. The Court of Appeals will overturn me. If I don't do it, the Court of Appeals will overturn everything. We've wasted a lot of time, and yes, it's mandated. Even if the parties stipulate to not do it, I've got to do it. Unfortunately, I prefer not to, believe me.
I do too.
Yeah, this is not a kind of case where the child witnessed a domestic violence, a violent act or drug use firsthand. It was simply, if the court recalls, that dad and a significant other were involving the child in adult issues unnecessarily, creating drama for the child. That's sort of the court's recollection. If the child has her own bedroom in dad's home, the court like to think we can go back to where we were prior to this ex parte order. Unfortunately, Mr. Paluk has decided to do what he wants to do, which is a concern to this court. He certainly brought his credibility into this issue. It's hard for the court to ignore that. But the court would hope that we can get back to some, she's 14, entering high school this fall, is that correct? 4 more years, she can do whatever she wants. And obviously, at her age, she's at tender age, a lot of emotions, being a young teenager, going to high school. The court would urge the parties, again, Mr. Paluk, to contact Miss Julian to talk with her, see what he can do to get to develop some alternative plan to avoid this hearing. The court would like to do that, but in any event, Mr. Paluk, can you raise your right hand to be sworn, please? Do you admit and acknowledge that you ordered back in, I believe, February of 2024, that your girlfriend, significant other, I believe her name is Ilana, shall not be in the presence of your daughter when you're exercising parenting time?
Yes.
You admit and acknowledge you violated that prohibition by having your significant other present when you're having parenting time with your daughter on 3 or 4 occasions?
Yes.
So you admit and acknowledge you violated this court's order, is that correct?
It was like, it's a tough situation. I understand that.
Sorry, it's a yes or no question. Do you admit and acknowledge that you violated this court's order?
Yes.
Right. Court finds Mr. Paluk to be in contempt of court reserve sentencing. And we'll address sentencing to our next future date, which is September 5, 2024, 8:30 in-person hearing. Once again, the minor child to be presented for interview Wednesday, September 4th at 4 p.m. Parties shall exchange witness lists on or before August 14th. Trial briefs on or before August 31st. In-person hearing, full day, September 5, 2024. Anything further this afternoon, Mr. Filkins?
No, Your Honor. Thank you.
Ms. McDonald?
No, Your Honor. Thank you very much.
All right, that will conclude this matter. These restrictions continue, Mr. Paluk. The prior orders of this court shall continue, and the court expects that you will comply with those orders. And neither party should be discussing this case with the child. She's a child. This is between the parents. And the court would urge you to act like responsible parents and work out your own differences. All right, that will conclude this matter. We'll see everyone then on September 5.
Thank you, Your Honor.
Thank you, Your Honor.
Zoom out. You're welcome. For the record, this matter is before the court for the purpose of reviewing and defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Lee Rourke, representing the plaintiff mother, Ashia Parker. Ms. Parker is present. In addition, defendant father Andrew Chapman is also present. Good afternoon, everyone.
Good afternoon.
The court has received the final recommendation from Mr. Walker this afternoon. The recommendation is as follows: that father shall participate in CPP therapy with the minor child Alexander. I believe that's child parent psychotherapy.
Yep.
Father and Alexander are currently on a wait list for therapeutic visitation at Family County Shelter Services, and that shall start as soon as possible. Supervised parenting time with the minor child Athena, and father shall continue through Family Counseling Shelter Services. Further, that supervised parenting time for the minor child Alexander shall terminate. And therapeutic visitation for minor child Alexander with transformational choices shall terminate. Finally, the parties shall appear back for this court to review parenting time July 23rd, 2024 at 2:30 p.m. We always want to keep this matter in the court's docket until we can get to some normal parenting time between dad and his son Alexander. So that's the recommendation. Ms. Rourke, is this recommendation agreeable with your client this afternoon?
Your Honor, the recommendation is agreeable with the exception of continuing the supervised parenting time as to Athena. she is in agreement with the rest of that recommendation.
So you're opposed to supervised parenting time with Dad and Athena through Family Counselor Shelter Services?
That's correct, Your Honor.
Okay, and what's your objection?
So the letter from Family Counseling and Shelter Services dated May 20th recommends that the case be referred for therapeutic visitation. So following our last hearing in February, my client had contacted Family Counseling and Shelter Services for therapeutic visitation, was advised that the wait list was very long and was not able to get any sort of idea of a reasonable start time for that service. She took it upon herself to find another facility that could offer that service, which is how we ended up with Transformational Choices and the consent order that we submitted to the court. There are all of the reports from Family Counseling and Shelter Services as to the supervised parenting time. None of them have been good, and we would argue have been traumatic as to both children. The recommendation from the 20th was, in our opinion, regarding both children. So we think that therapeutic parenting time as to both of the children is in their best interest. My client did confirm with Family Counseling and Shelter Services before court this afternoon that they are still on the wait list for therapeutic parenting time. So we don't have an estimated start date for that. However, this would not be a new addition to a wait list. They've been on it for approximately 3 months at this point. Part of the issue here, and especially as it relates to Alexander, is Mr. Chapman has refused to follow through with his therapist's recommendations that he be participating in the CPP therapy with Alexander. Prior to December, Mr. Chapman had started that process. However, after January, he never followed up. I mean, that's 6 months where there's been nothing ongoing. I would argue that we may not even be in this position if he had followed through with that. My client's been fully compliant with Family Counseling and Shelter Services. I think she's been more than reasonable. I would argue that she's gone above and beyond to try to facilitate the relationship between the children and Mr. Chapman, including my client is the one who took it upon herself to find another option for the therapeutic parenting time that was not Mr. Chapman. But overall, our understanding of the reports and letters from Family Counseling and Shelter Services, they do reference Athena. It has not been a positive experience for her. She has not participated in any visitation. I know that pursuant to one of the notes from Family Counseling and Shelter Services, I believe it was the one dated April 18th, they outlined that, the visit coordinator will ask a child 3 times in a visitation day to participate, and they're not going to pressure or force the child to go into the visitation room, but they will make a cohesive and full attempt to give a child the opportunity to visit. They have done that with both children, Athena included, to no success. And so we don't believe that continuing to have that negative experience is going to be beneficial for the relationship between Mr. Chapman and Athena, and certainly not for Athena's well-being.
All right, I didn't realize the court is not in receipt of those reports. Mr. Worker, they go to the front of the court, so Mr. Walker has reviewed those reports, and I'm sure he has done so before they make this recommendation. There needs to be some contact between Dad and Athena. So if you're opposed to supervise with Family Counseling and Shelter Services, why don't we go back to this alternative of Transformational Choices holistic therapy? What about that?
The reason that we're requesting that the therapeutic be transferred to Family Counseling and Shelter Services is because the therapeutic visitation at that agency has not gone well. I think an integral part of having a third party involved in parenting time, especially therapeutic, is to be able to have progress reports and notes to determine how that's going. My client multiple times in the last several weeks has requested progress notes, things to that effect, for us to be able to update the court, and has not received a response. The other issue is that they draw a very sharp distinction between therapeutic parenting time and supervised parenting time. And so essentially, even though it's therapeutic, they're not supervising it. There was, and by that, I mean in the the start of parenting time and the end of the parenting time with the exchanges between the parties. It's our understanding, or my understanding, that approximately a month ago, there was an issue after the therapeutic session had concluded, but before the children were returned to my client, where Alexander was in the restroom. Mr. Chapman took a phone call. There was not anyone else present. And following that event, is when the meltdowns with Alexander began increasing, and his refusal to go back to visits, including throwing himself on the ground, hitting himself. If the court recalls, that child has a diagnosis of autism spectrum disorder, as well as post-traumatic stress disorder. And it's been documented by his therapy team on multiple occasions that Mr. Chapman is certainly a trigger for Xander. So we don't know what happened at Transformational Choices during that visit, but it's not been to a positive effect. Really, the support that Alexander needs specifically for parenting time with Mr. Chapman is that CPP therapy. That therapist will engage and focus on the relationship between Mr. Chapman and Alexander. My client has been engaging in CPP therapy with Xander since he began. She's also coordinating his OT and speech therapy and all of the other things that he has going on. Mr. Chapman has been given the information for CPP repeatedly and is not engaging. I understand he has another child. I understand he has to work. I understand even that he has to take care of horses. But that really is the vital component, I think, that's missing here. And I don't know, it's my hope that therapeutic parenting time at Family Counseling and Shelter Services will have a better result. But I really think that CPP therapy is what needs to happen for there to be any rebuilding of the relationship between Xander and Mr. Chapman going forward.
Right. No question the CPP therapy will benefit the minor child Alexander, and then hopefully father as well, but the courts may concerns minor child Alexander. So Mr. Chapman's going to have to step up and immediately re-engage in that program. But if the court understands, Ms. Ricca, Ms. Maris wants to be no contact between dad and the minor child Athena until there's therapeutic visitation available through Family Counseling Shelter Services. Is that correct?
Your Honor, that we believe that is the recommendation, that she should also be doing the therapeutic without the supervised, based on the reports we've received from Family Counseling and Shelter Services.
Well, again, what's the wait list?
I don't know the answer to that, Your Honor. My client did confirm they are still on it. It would not be a new addition to the wait list. They've been on it.
Could very well be months, and the court is reluctant to deny this child contact with a parent for months and months. Obviously, the child is protected if it's supervised parenting, Ms. Worker and Mrs. Mayoris. So does Ms. Mayoris want that supervised parenting time to be with Family Counseling Shelter Services or Transformational Choices, holistic? I'm sorry, Ms. Parker. I'm sorry. I'm looking at my docket, and I'm sorry. I apologize. I'm not referring to Ms. Mayoris, but Ms. Parker. Court stands corrected.
Family Counseling and Shelter Services.
Right. All right. Mr. Chapman, you've heard the recommendation. You've heard the input from Ms. Worka.
Yes, Your Honor.
Anything you want to add? Are you committed to the CPP therapy? It's what, through U of M, is that correct?
It moved to Great Lakes Prenatal Wellness. It's the same person. She graduated her program and now is individual practice.
Okay, Mr. Chapman, you have the contact information. Is that correct?
Yes, I believe Ms. Parker is sending that to me again today, and I am committed to continuing the CPP therapy. As to waiting, untold months before I can have time with Athena and Xander, I feel like I've already missed out on so much that it isn't an adequate amount of time to build and maintain a relationship with my children. I am completely opposed to having to wait an untold amount of time before I can have visitation with them.
Mr. Chapman, it's court's recollection that back in September of 2023, we talked about engaging in this child parent psychotherapy at U of M. Did we not? That's the court's notes, and that's September. So a lot of delay is on your part.
Yes, Your Honor.
Mr. Walker, is there anything you wanted to add?
Not really, Your Honor, just that my interpretation, I suppose, of the reports from Family Counseling and Shelter Services seem to focus on Alexander, which I think they should have, but they did. They focused on Alexander. They did not. They mentioned Athena once or twice. I do not see where they mentioned that Athena should not continue, only that Alexander should not continue. And that's why I made the recommendation that I did, Your Honor.
So, Mr. Chapman, will you have supervised until such time as therapeutic is available?
Yes, Your Honor.
Yes. Well, it's supervised with Athena, not supervised with Alexander. Alexander's supervised should end, but Athena's would continue.
Okay, all right. All right, so anything further, Ms. Worka or Mr. Chapman?
No, Your Honor.
Your Honor, just that, like I said, our reading of that letter from Family Counseling and Shelter Services yesterday does mention Athena and recommends that the case be referred to therapeutic visitation without the supervised. We think that applies to, our interpretation is that should be applied to both.
All right, thank you, Ms. Worka. And obviously therapeutic is preferred, but the court, the downside is that Mr. Chapman will not have contact with this minor child, Athena. So the court's going to adopt the recommendation of Mr. Walker this afternoon. We're going to review this matter July 23rd at 2:30 p.m. Supervised parenting time for Alexander shall terminate. Supervised parenting time with Athena will continue through Family County Shelter Services. Mr. Chapman, follow up with CPP. Get going on that so we have some real progress between now and July, and also keep checking with that agency, Family County Shelter Services, to get on that. Tell me you're really looking forward to that therapeutic parenting time with Alexander as soon as it's available. So maybe the squeaky wheel will get some attention. So that's what the court would suggest.
Your Honor, if I
Yes,
may also add that by engaging in the CPP therapy, that is an opportunity for Mr. Chapman to have parenting time with Alexander.
I'm sorry, that he have contact with through that agency?
I'm sorry, Your Honor.
And so your suggestion was that Mr. Chapman have parenting time with both children with the CPP, but as part of the CPP therapy?
So my client has Athena at CPP therapy every week with Alexander. I just was reiterating that CPP therapy, it will be an opportunity for Mr. Chapman to exercise parenting time.
I see. So it's the same therapist?
Yeah.
That's dealing with dad and both children? Okay. All right. So Mr. Chapman, that's the key. You really got to get involved in that. Make that call today. Schedule that.
Yes, Your Honor.
Thank you for that information, Ms. Worka. All right. The court will adopt the recommendation. We'll see one back then on July 23rd, 2:30.
Thank you, Your Honor.
Welcome. Now conclude this. Everyone can zoom out. For the record, this matter is before the court on the plaintiff mother's motion to modify parenting time. This hearing is being conducted via Zoom. President's Attorney Leslie Carr representing the plaintiff mother, Amber Urschenauer. Ms. Urschenauer is present. In addition, defendant father Gregory Powell is also present. Good afternoon, everyone.
Good afternoon, Your Honor.
The parties have conferred with Ms. Patrick from the front of the court. This afternoon has provided the court with a fine recommendation that there's an open DP file, which is 2023 consolidated into this DS file. Further, that father's parenting time be suspended and that the parenting time be reviewed on July 16th, 2024 at 1:30 p.m. Ms. Carr, presumably this recommendation is agreeable with your client?
Yes, Your Honor.
Right. Mr. Powell, do you understand the recommendation?
I do.
Do you have any objection to the court adopting this recommendation? We're going to take a little break from parenting time and come back on July 16th at 1:30.
Absolutely, I object. The charges that they were concerned about me being incarcerated for were already PR'd.
Okay, but they're still pending.
Yes, they are still pending, but they were PR'd on.
Okay, that's fine. I can see you're not in jail, so you're out of jail. So you had a pending domestic violence second offense as well as the driving license suspended. Are those the two charges that are pending?
Yes.
So you don't have a valid license right now, do you?
No, but I do have a driver.
Okay. Who do you live with?
I live with my girlfriend.
Okay. What is her name?
Her name is Samantha Short.
Is she the victim in the domestic violence?
Yes.
Okay. And I'm surprised that there's not a bond condition. They have no contact with her while this charge is pending.
It was, but it was lifted. Yeah,
well, obviously
those charges were pending to be dropped, which is why I have a PR bond.
No, the PR bond is just you were released from jail without having to post any cash bond or surety bond. Mr. Paul, has nothing to do with the adjudication.
No,
you're presumed to be innocent, but until it's adjudicated, the court has a concern.
That's just what I was told by my lawyer and prosecutor.
Okay. Ms. Carr, did this alleged incident take place in the presence of the child?
No, I do not believe so. And I can report that Mr. Powell is set to be sentenced on June 27th. The domestic violence has been dropped to an assault and battery. The driving with a license suspended, he has also a contempt proceeding with respect to that, and a contempt proceeding with respect to several other traffic tickets. And they're all set for the same date on June 27th in District 2A in Adrian.
Okay. And currently, dad's parenting time is alternated weekends, correct?
Yes.
Okay. Perhaps we can move up this, of course, adopt recommendation. Perhaps we can move up this review to sometime shortly after January 27th. I'm sorry, June 27th. And your concern, Ms. Carr, is that we need to make sure that Mr. Powell is not going to be. What's your concern that in case he's sent to jail?
Well, there are concerns about jail sentence, but there's concerns about the overall condition of the children while in Mr. Powell's care. And I would note that since the beginning of April, he's had the children overnight one time. And during that time, I mean, it was difficult because the children are reporting that they are not being cared for in his care, that they are not being fed, that Mr. Powell is sleeping until all hours, and they fend for themselves. There was an issue with the bond during that particular parenting time where the sheriffs were at his residence during that parenting time. Because there was a no contact order at that time. There's a dispute amongst the parties as to whether the other person was there, but the sheriff informed my client that the girlfriend was there at that time. And so my client just has a lot of concerns about the care of the children. One of the children reported that their son, who is being tested for autism, was struck by Mr. Powell during a parenting time several months ago. That information didn't come out in a timely manner, and by the time it did, my client didn't feel that it was appropriate to contact any authorities, although I think she's second guessing that now. But you know, there's just a general concern about the care in Mr. Powell's custody at this time.
So how's that going to change in your client's opinion between now and July 16th, Ms. Carr?
Well, it likely will not. But my client was willing to allow some parenting time. We just didn't want the overnights because things seem to be there seem to be issues with the overnights and the children getting up and the parties not getting up. So we were more interested in moving the parenting time to a few hours during the day and seeing how that goes, and then maybe seeing how the care and custody of the children are moving forward.
Okay, the court's reluctant to just cut off contact between the father and the children, but the court is concerned about the girlfriend, the alleged victim, being there. This victim, it's no longer an alleged victim; it's a victim of assault and battery. Mr. Powell, are you engaged in any type of anger management counseling program?
No, I am not. But those charges are pending to be dropped, like I said, and that no contact order was lifted based upon that.
I understand no contact, but there's a concern when you've got a volatile relationship at your home with your girlfriend. And again, if it's been reduced, it seems unlikely that it's going to be dropped after it's been reduced from a domestic violence second to an assault and battery. The courts want to see that you have completed some type of anger management counseling program. The only way the courts can allow even daytime parenting time is if, in fact, the Samantha Short is not present. So how do we know where do you want to exercise parenting time? If we talk about during the day on Saturdays, for example, or Sundays, do you have a parent that you can exercise your parenting time at a parent's house?
No, unfortunately, my parents don't live here.
Okay, well, again, we need to, obviously the children are old enough, they're 8 and 6, they could report to mom if the girlfriend is there, correct, Ms. Carr? If the court permitted some daytime parenting time?
Yes.
All right, Mr. Paul, are you currently employed?
Yes.
Okay, do you work on Saturdays and Sundays?
I do, but I don't have to. I cut hair every day.
Okay, well, with the court, rather than just suspend parenting time, the court would, is inclined, if mom doesn't have any strong objection or can't convince the court otherwise, to grant you some parenting time, but no overnights until we get past the sentencing. Not only past the sentencing, but also that you complete an anger counseling program. This is originally a domestic violence second, so there's a prior domestic conviction somewhere. So the court wants to, until we can allow any overnights, you need to complete a anger management counseling program. The children do not need to be a part of it. They didn't witness this, but we don't want there to be a future incident where they witness their dad becoming physically violent with another party, another adult. That's not a good thing for children.
Yeah, they've never
what's better for
witnessed
you?
that. I'm sorry?
Saturdays or Sundays, Mr. Powell? What's better for your schedule?
Sundays are fine.
Ms. Carr, what about your client's position on Sundays? Do you want to talk with Ms. Patrick about that, or do you want to in a breakout room?
Sundays are okay with me.
Okay. Obviously, the court would like input from both of you in terms of what's best for the children's schedule. We can set a review sometime in this, perhaps, and keep this July 16th review date with the idea that the court's strong suggestion, Mr. Powell, if he wants to normalize things, to take in complete anger management counseling program. In the meantime, so we'll do parenting time. Ms. Carr, what alternate Sundays or every Sunday for maybe 3 or 4 hours, half a day?
Alternating Sundays are acceptable to us, and I mean 4 hours would be fine.
Hey, what do you suggest, Mr. Powell? Ms. Eisenhower, like 12 to 5, maybe?
12 to 4, 12 to 5, that's okay with me.
Okay, how about 12 to 5 alternate Sundays? Would this coming weekend be Mr. Powell's weekend? Of last weekend.
It was his weekend this last weekend.
Okay, did he exercise for any time last weekend?
No, my daughter asked if she could go to her friend's house, and he said it was okay, so they did not go over there. So this weekend is fine too.
Okay, this is Memorial Weekend. Do you have? Do the children have plans with other family members?
No.
Okay. Okay. What about alternating Sundays starting May 26th, 12 to 5? And Samantha Short shall not be present. Mr. Powell, are you willing to comply with that?
I don't really have a choice.
Okay.
If that's the only time that y'all giving me to see my kids, then I guess I have to accept that.
Okay. Well,
it's either that or nothing, right?
Yes, and what the court's strongly suggesting, if you want to normalize things with children, first of all, it sounds like you've been sporadic in the past, but you need to complete an anger management counseling program. So you can contact the probation department and ask for an agency that to offer such a program.
Okay.
And you can have that maybe done by July 16th. Some documentation, complete an anger management counseling program. We just don't want you to there be no any incident in the presence of the possibility of that in the presence of the children in the future. So the court will modify the recommendation. Follows parenting time is modified this time, noon to 5, alternate Sundays beginning May 26th. And the parenting time shall not occur in the presence of Samantha. What's her name? Samantha Short.
Yes.
Is that her name? Okay. Samantha Short.
Okay, so she has a relationship with the kids as well, and there are other children that live here. So what we're asking is that I ask her and her children to leave the home so I can have
go to a park. Go to a park.
Oh, okay. Okay.
I mean, this is parenting time for you, not for her. This is for you.
No, I understand that, but okay. Okay.
And perhaps, Ms. Patrick, you can note in the recommendation, the court recommends that Mr. Paul complete an anger management counseling program.
I have it modified the recommendation to what's been stated on the record, Your Honor.
All right, so Ms. Carr, anything further?
No, Your Honor.
Okay, and do the parties meet, or how do they transport for the exchanges?
They meet at Arby's in Dundee. Is that still the case? Okay. Now I don't know who will be driving for Mr. Powell because Ms. Short was his driver.
Mr. Powell, who will be driving to the Arby's in Dundee?
I have no answer for you at the time. I mean, I don't know. I'll have to figure that out.
Okay. Well, is Ms. Short going to be driving? You know, I guess as long as you're supposed to be not in the vehicle with her. But I don't know, Ms. Carr, is that even acceptable? If Miss, I don't know if your client's comfortable with Samantha Short picking up the children. Do the children know her well enough?
Yeah, they do know her well enough, but I've only ever seen her one time in person. So I'm not sure if she will do that, but I'm willing if she is.
Okay, so you're comfortable with Samantha Short picking up the children, is that correct?
Yeah.
Okay, so I guess if Ms. Short wants to pick up the children and she's got to deliver them to you, Mr. Powell. Any questions, Mr. Powell?
No, I don't have nothing.
Okay, so and if she can't, if someone can't pick up the children, then you need to, as courtesy, let Miss Amber know that no one's going to be there. She shouldn't have to go to Arby's and Dundee with the kids, and the kids are expected to see their dad, and it's not going to happen. So if you don't have a transportation lined up, as courtesy, let Amber know that you're canceling that parenting time session, and you can then continue at the alternating Sundays thereafter. We'll come back on July 16th at 1:30. All right, if there's nothing further, I'll conclude this here. Never can zoom out. Thank you, Ms. Patrick, for modifying that. Attorney Leslie Carr, representing the plaintiff mother, Amber Eschenauer. Ms. Eschenauer is present. Is Gregory Powell present on audio? Mr. Powell? Okay, apparently he's not appeared. Ms. Carr, have you or your client heard from Mr. Powell this afternoon or this morning?
No, my client did attempt to contact him. She called him and she texted him, and he has not responded to her.
Okay. This matter was scheduled for 1:30. It's now 1:50. Mr. Powell has not appeared. He's not contacted the court. Is Mr. Powell exercising the parenting time he was previously awarded, alternating Sundays?
He's only exercised the parenting time twice since May 21st. So out of the 4 or 5 times he could have, he's done it twice.
Most unfortunate for the children. Well, the recommendation, Mr. Walker, is that the parenting time be suspended until further order of the court, until he petitions the court.
We have no objection to that, Your Honor.
Ms. Carmen, I just wonder if we should modify this language to say that because he's improper, maybe just suspended until he petitions the court. Any objection to that?
No.
Mr. Walker, I'm sorry. Most unfortunate. All right. All right. That will adopt the amended, modified recommendation. That will conclude this hearing. I'll zoom out.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Mr. Walker. Okay. For the record, this matter is before the court on defendant's motion to modify custody and plaintiff's motion to change domicile. This hearing is being conducted via Zoom. President is Attorney Maria Zagorski, representing the defendant, Father Brian Sargent. Mr. Sargent is present. In addition, plaintiff mother Mary Nagy is also present. Good afternoon, everyone.
Good afternoon. Yeah.
Ms. Pratt has provided fine recommendation. The parties have agreed to mediate on June 27th, 2024 at 1:30 p.m. That mediation will involve plaintiff's mother to change domicile. Is that correct, Ms. Zagorski?
We can talk about that, yes.
Okay. Obviously, that's relevant to parenting time. It's further recommended that in the event mother stays in Michigan, parenting time shall remain per the current court order, which is dad having Saturday 6 p.m. to Tuesday evening on week 1 and Friday and Saturday overnights on week 2, if court recalls. In the event the mother moves to Florida, the minor child shall remain in Michigan, and parenting time shall be referred to the front of the court for report and recommendation. So that's the recommendation. Ms. Zagorski, is this recommendation agreed with your client this afternoon?
It is, Judge. I just need the court to know that I did amend his motion for custody for a couple of reasons. First of all, it's an appropriate response to a motion to change domicile, but also because in light of recent actions, my client sincerely believes that the child would be better served being in his primary custody. So we do want the court to be aware of that motion as a standalone issue, regardless of the motion to change domicile.
Has that motion been filed?
Well, he filed the motion to change custody on his own before I entered my appearance, and I just amended it. It should be making its way to the court file. It went over there this week.
Okay, I don't see in the court file.
I
So
did
Mr.
an MCL 722.23 best interest analysis and set forth why we believe that a review of custody is appropriate at this time.
Are you
But
sending
we'll
over
cross that-
judges?
I'm sorry?
Did you send over a judge's copy?
We always do. I assume that Jill
Okay.
did. And, you know, so we would be going into mediation with an eye toward talking about custody, change of domicile. You know, if Ms. Nagy is intent upon going to Florida, then we need to be talking about a parenting time schedule that allows Everett to go and travel to see her, is our position.
Okay. Maybe it's en route. Okay. Okay, yeah, nothing's been filed with the clerk's office yet, so maybe it's not yet been delivered, but maybe we'll look for that.
Okay, thank you,
All right.
Judge.
Okay, so you have no objection to the court adopting this recommendation of mediating on that date?
Correct.
All right, Ms. Nagy, do you understand the recommendation this afternoon?
Yes, I do.
Okay, do you have any objection to the court adopting this recommendation?
I do object. I don't think that Everett should remain in Michigan with his father. However, if I am not able to take him with me, I will not be moving. I also do not agree with Brian having sole custody of my son.
Well, yeah, that's my understanding is that's what he's asking for if in fact you move to Florida, that the Everett stay here in Michigan. Then there'd be parenting time for you in Florida, presumably during the summer months. So I guess you've got to make that decision whether or not you really want to move to Florida. Could mean with or without Everett. We need to have a hearing on that matter. Are you going to retain an attorney, Ms. Nagy?
Not at this time.
You may be well advised to do so. This recommendation that if the mother chooses to move to Florida, the child remain in Michigan, that's just until such time as the court makes a determination. Is that correct, Ms. Gorski, Mr. Brad?
Yes, if we had a hearing and Ms. Nagy carried her burden of proof, then, and I failed in my burden of proof regarding changing custody, then the court would issue its order at that time.
All right, okay. All right. All right, these are very critical decisions you made, Ms. Nagy. And the court needs ultimately, if you cannot reach your own agreement, then the court will have to make that decision after conducting a hearing and scheduling testimony. Ms. LaPrada, could you simply add this, the party shall appear before the court subsequent to the June 27th mediation?
Yes, sir.
Stand if they don't have agreement, the court will schedule a evidentiary hearing. All right, anything further this afternoon, Mr. Gorski or Ms. Nagy?
No, thank you, Judge.
Okay. All right, the court will adopt the recommendation just with the added provision that after the June 27th mediation with Ms. LaPrada at 1:30, the court parties will appear before this court to advise and inform the court where things stand. Okay, that will conclude this hearing. Everyone can zoom out. Have a good rest of the afternoon.
Thank you.
Is Attorney Maria Zagorski representing defendant father Brian Sargent. Mr. Sargent is present. Plaintiff mother Mary Nagy is also present. Good afternoon, everyone.
Good afternoon.
Good afternoon.
If the court's recollection, the issues, Ms. Nagy filed a motion to address the school district. Is that correct, Ms. Zagorski?
No, mom wants to move to Florida with the minor child.
Oh, a change of domicile.
Yep.
That's correct. And there was a motion to change domicile filed, correct?
Yes. When my client was informed by Ms. Nagy that she intended to move, he filed a motion to change custody. She filed a motion to change domicile, and then I amended his original motion to hit on the statutory factors.
Okay, I was looking for the original motion to modify custody. That was followed by Mr. Sargent in pro per. Then is that correct?
That's correct, with a friend of the court. Yes.
That's why I could not find that. I do see the motion followed by Ms. Nagy seeking to move to Florida. And the course informed the parties weren't able to reach an agreement. Is that correct?
That's correct.
Right. All right. So can we do a half day hearing? Ms. Nagy, are you going to represent yourself or are you going to retain an attorney?
I'll represent myself.
Okay. The court's going to want you to file a trial brief. It's involved. So just so you're aware that you need to file with court a trial brief in terms of addressing the issues. It's not just a simple 5-minute hearing. You understand that?
Yes, I do.
Okay. All right. Ms. Skorsky, how many witnesses do you anticipate?
At this point, apart from the parties, I have 7.
Okay. Can we do it in half a day?
I can be quick.
All right.
Yeah.
Okay.
Well, Judge, you know what? I'm thinking some of these are family members, my client's wife, his mother, the person from the preschool. You might be safer with a full day. I don't want to have to break this up.
Okay. How about August 15th at 8:30?
I am on vacation that week, Your Honor.
When does school start? It starts the last week of August, correct?
My client's in the Ida district, and he would like the child to attend preschool this year. So we're fine anytime in August. The parties haven't decided on a preschool yet either. I don't know when it starts in Florida. I defer to Ms. Nagy.
Ms. Nagy, when does the school start in Florida?
It does start in August. I had the form.
We would start September 9th in Ida, I believe.
Maybe the 3rd.
You can assume that school will start anywhere the last week of August. August 22nd then is probably too late, correct?
Well, yeah, because you won't have any time for enrollment.
I'm scheduled to be in mediation with Mr. Godfrey on the rider matter that day, Judge.
Okay. Ms. Nagy, when are you moving to Florida?
I would like to go as soon as possible, as soon as I'm allowed.
Hold on. Ms. Nagy, you can move. You can leave tomorrow. You just can't take the child with you.
Yeah, I'm aware.
Okay. All right. I just said the court's not depriving you. You can do whatever you want.
Yeah, we just don't have anything in. We don't have anything in place, so I didn't want to move without my child yet. Right. Until things were in place with her father.
If the court does not permit the change, are you going to remain here in Michigan?
Yes, I would.
All right. Okay. All right. So it's gonna be. We'll need to squeeze something in before August 15th. Then, if the 15th is not good for Ms. Sikorsky.
The first day of school for the elementary school in Florida is August 12th.
Yep. Okay. Do we have anything the first 2 weeks of August? About August 1st, it's a Thursday, 1:30.
I am in trial with Judge Lohmeyer on that date.
All day?
I hope not. It's the 3rd of a 3-day trial. It's a pretty nasty one. We are, let me see. Sorry, Judge, my phone is very small. We have that scheduled for, I'm sorry, that's the first day of the trial. That's scheduled for the 1st, 2nd, and 5th with Judge Lohmeyer.
Okay. All right. Okay, we have to look at it Monday then. How about July 22nd? 8:30?
I'm available. I would just have to move my mediation with Ms. LaPrade. But I'm sure we can move that mediation.
What about the 29th of July? 22nd or 29th? I'm running out of dates.
I'm in mediation with Ms. LaPrade. So either way, I'm going to have to move a mediation.
What do you prefer?
The 29th.
What about August 5th? That's another Monday.
That's the 3rd day of that Hill trial with Judge Lohmeyer.
So what do you prefer between July 22nd or 29th?
The 29th would be better for me.
All right, is it 8:30? That's be an in-person hearing.
Okay.
All right, Ms. Nagy, let me just make sure we got your current address. Mailing purposes. It'll be an in-person trial, July 28th, 8:30 a.m. And the court will order that the parties provide the court with a trial brief on before July 22nd, the Monday before that.
Okay.
I would encourage the parties to talk, but obviously it sounds like a resolution is unlikely since Ms. Nagy's determined she's going to move to the state of Florida. The parties have joint legal custody. Is that correct, Ms. Sikorsky?
It is, Your Honor.
Okay.
My client has parenting time 6 out of 14 days.
So presumably there's an established custodial environment with both parties.
That would be my assertion. Yes.
Okay. So Ms. Nagy, the court would again strongly recommend you to talk to an attorney. When there's an established custodial environment with the child with both parents, the burden of proof is significant. It's by clear and convincing evidence. So it's a higher hurdle than if the established custodial environment, the child was just with you. So it's you got to heighten the burden, and let's see, it's your burden to prove that. All right, so July 29th at 8:30 in person, and with trial briefs due on before July 22nd.
Okay.
Any questions, Ms. Nagy?
No, sir.
Okay, and the court will address not only the plaintiff's motion to change domicile, but defendant's motion to modify custody. Presumably, the motion to modify custody would only be really relevant if, in fact, Ms. Nagy moves, correct, Ms. Sikorsky, if she decides that she's going to Florida without the child?
That's procedurally, I think, the norm. I think after the court hears all the evidence, it will be persuaded that a change in parenting time, it would benefit the child as well.
Okay.
Or custody. I mean, I don't really care what we call custody as long as it remains joint legal, but I think parenting time, the court will find that parenting time, the child would be served by spending more time with his father.
Very well. Any questions, Ms. Nagy?
No, sir.
Okay. That concludes, you can all zoom out. Have a good rest of the day.
Thank you.
You too. Thanks.